And now to the courts. The Supreme Court has dismissed an application by Speaker of Parliament Alban Babing, who sought to overturn the court's ruling that suspended its declaration of 4 parliamentary seats as vacant.
This follows an initial suit filed by Efutu MP Alexander Afenyo-Marking challenging the Speaker's declaration. The Speaker's legal team argued that the Supreme Court lacked jurisdiction in this case, among other grounds canvassed in court. However, after hearing arguments from all parties, including the Attorney General and Minister for Justice, the Supreme Court maintained that its earlier ruling was appropriate, stating that the Speaker's appeal was without merit. Prior to this decision, the court also dismissed an objection raised by Thaddeus Sori, counsel for the Speaker, regarding the empanelling of Justice Ernest Gow. Mr. Sori argued that Justice Gow's past role as a parliamentary candidate for the New Patriotic Party NPP suggested a potential conflict of interest. However, the Supreme Court rejected this claim. This ruling comes after the court on October 18 instructed Parliament to allow the 4 MPs to continue their duties until the case is resolved, effectively pausing the Speaker's declaration on October 17. This decision holds particular significance as both sides in Parliament currently claim a majority.
This is adjourned to Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this is to enable parliament. It's to declare.
Very well. I take it. That's really in your
so
own
if I would plead that because let's look at the time that we are closing and the fact that we've done some work, filing it by Friday is not it's not possible. I also need to still go and take instructions, so maybe next week is fair. Today is Wednesday. All right. At least if I'll take 7 days to file the 2.
No, do not count your 7 days from today. Your 7 days started running from 21st. You cannot make your own rules.
I'm just praying the court. I'm not making rules.
Joining us via phone for a conversation into the Supreme Court's ruling is a legal practitioner, Osman Al-Hassan. Osman, thank you for your time, Counsel. You're welcome. Good afternoon to you.
Good afternoon and good afternoon to your listeners and viewers.
Now, firstly, how should the nation take this whole case and on top of it, its ruling?
Well, it's an unfortunate situation. We have had a situation where issues should have been approached and resolved politically, and our judiciary is being drawn in. And the judiciary, in my view, is making political decisions rather than judicial ones. And so we should see it as positive and negative. Positive in the sense that our constitutional principles and institutions are being tested, which, if we are able to come out successfully, will make them stronger. We just hope that we don't get too much bruise after this. And it's bad because we are approaching an election, a general election, and the tension that it is heightening is not conducive for such an election. And so that's how I want people to look at it and see it. But it is something that could have been resolved if the president probably had shown some leadership and someone, his members of parliament, to approach it politically. Let them have a consensus over matters and proceed. Because parliament itself is left with very limited time of its term.
Right. So you say that the court is making decisions that are, borders on political issues and not judicial. I mean, in this case, where you have parties to this matter taking it to court, the court really does not have any choice but to sit on these cases that have been brought before them, not so?
No, if the court has no jurisdiction over matters that are brought to it, it should be bold enough to decline jurisdiction. And the Supreme Court has done that over and over again. And this is one of the cases, I think.
And in this case, we're referring to the Supreme Court.
Yes, the Supreme Court doesn't have jurisdiction over all matters. the jurisdiction over the Supreme Court is conferred by the Constitution and the laws of the country by themselves. And so where they don't have jurisdiction, they have over the time declined jurisdiction. And matters of this nature came before them earlier. And they had declined jurisdiction, that they don't have the jurisdiction to enforce those constitutional provisions. Mm-hmm. And so if you go to the proper fora, I don't know why this time the Supreme Court cannot do the same.
Is it every decision taken by the Supreme Court at some point in time regarding cases that are binding?
Well, Supreme Court decisions should be binding only to the extent that those decisions themselves do not intend to suspend the Constitution. You know, the Constitution itself has made provisions to jealously guard against its existence and perpetuity. It has arrogated to itself the supremacy of all laws and commands subservience from all institutions that it has established, including the Supreme Court. So if the Supreme Court makes an order that is seeking to suspend an application of a constitutional provision, in my view, I don't think it should be binding on anybody, because the Constitution is supreme. The order the Supreme Court has made in this case is technically to tell Parliament to stop applying Article 97G and H until the Supreme Court gives meaning to it. Meanwhile, the power or the authority of the Supreme Court in the Constitution is for the Supreme Court to make these orders after it has declared, or it has exercised the jurisdiction to declare some conduct unconstitutional. You haven't declared any conduct unconstitutional, and you are issuing orders that seek to
which is why you're describing the Supreme Court's action as political and not, judiciary.
Okay. If you look at the order that they have made, looking at the interlocutory order that they have made, which they call stay of execution, and which I always refer to stay of constitution, they say in it two things that will tell you that it is political and not judicial. One, that they are giving that order to save the thwarting of government business. Do you know what that means? Thwarting of government business, which means that in the mind of the Supreme Court, the business of the government will be thwarted if the minority becomes the majority. And so the business of government will proceed if the government remains majority or have majority members of parliament in parliament. And so this order, according to it, was given in order to save that situation. The second grounds they say warranted the order was that they wanted to protect the rights of people who had elected for those members of parliament to have continuous representation in parliament, and the right of those members of parliament to continue receiving salary. Come on. Is that justice? No, it's not justice. If you say you want to, why? We have instances in this country where the Supreme Court had the opportunity to grant people a representative in parliament until final decisions of court are made. And they prevented that by issuing an injunction. Weren't we here? You weren't here when the Supreme Court issues an injunction against James Gyekye Quayson when he had an appeal about his own situation pending in the Court of Appeal for hearing. So if the Supreme Court were minded to be protective of citizens' rights to have representation in Parliament, the most important or obvious thing to have done in the Gyekye Quayson's case was to allow Gyekye Quayson to continue representing them until the Court of Appeal decides. But what did they do? They issue an injunction preventing him from that representation until a by-election was run. And again, we have a situation of SAL right before our eyes. for the whole term of Parliament, a whole constituency is not represented. And the Supreme Court had an opportunity to make pronouncements about this case. And they didn't protect the rights of those people to be represented. And so if it comes to this one, and they are concerned with protection of the rights of people who were represented, then do you expect me to think any differently? That the decision is more political than judicial? I don't think so.
So where do we stand now? We have, so from the first case where the leader of the then majority went to court, I'm actually was expecting that people would be expecting the court to give us an interpretation on Article 97, which we didn't get or we don't have yet, and then followed this matter of the speaker, which the court's ruling was to throw it out or to reject it. Where is the case hanging now?
Well, the Supreme Court, from the last orders made or directives given by the Supreme Court, is that the other parties should file their response. But the point is that if the Supreme Court actually deemed this matter that urgent, if you give time, if you give a party an opportunity to be heard, and the party refuses to utilize the time to be heard, you proceed to give a meaning. Proceed to do what you think you have authority to do. But in the first place, for me, the Supreme Court has no jurisdiction in this matter because there's no issue of interpretation at stake. The Supreme Court has no exclusive jurisdiction over interpretation of facts. What is presented to the Supreme Court is inviting the Supreme Court to interpret facts. That whether contesting as an independent candidate constitutes leaving the party, or what intention is behind it, is future and past, and all those things. They are interpretation of facts, not the Constitution. And secondly, we all know that, and the Supreme Court admits that Article 99 of our Constitution confers the jurisdiction to determine whether a seat is vacant on the High Court. So why are they assuming jurisdiction?
You have other senior lawyers who have spoken against this. Kwame Akufo has spoken against decisions of the Supreme Court. We have Kwekwaza, all have spoken against this. We've had even the circulars of the courts being, banded about or circulated, reminding the court of its own rules of how even service is done. So all these points out that you lawyers are doing. How do we do the corrections? The Supreme Court has spoken and it's almost like it's final.
Well, the Supreme Court said the order should remain and that they should file further processes for the determination of the substantive matter. So now, if the order they have given remain in force, to what end? What effect does it give us? Because the most important thing is for Parliament to do business. And as we speak, because of these issues and because of the legalese around it, Parliament cannot do business. If they summon Parliament today, and I understand recently that the Speaker is out of the country on another official assignment, who presides? The Deputy Speaker is from the other side. And if he presides, will they have a quorum and all those things? So it will lead to another adjournment. If it's a mess. And I think that this is a situation that leadership should have prevented. Because if you don't have numbers in Parliament, you use consensus. You should be seen as the one building consensus.
Right.
No government or president is guaranteed majority in Parliament. No. Our Constitution expects that a president can have minority in Parliament. And so if you are unable to govern the country with minority, it tells about your competence, rather, your leadership competence. And it is not about thwarting government business, as the Supreme Court wants us to understand. So it means that always when the ruling government loses majority in Parliament, then government business is thwarted. What kind of reasoning is this?
Right. Right. Counsel, we'll leave it here. Usman Al Hassan, private legal practitioner. Thank you for your time.